work that you've done with the stakeholders and many of us here on the floor of the Senate. I want to point out in section 1, because I think, as you know, we took some very difficult testimony, okay, about the survivors of sexual assault and the deprivations against children that have occurred. And I want to point out what I think are tremendous changes that support the survivors of sexual assault in this bill. First off, on the first page, you strike daily routine and you substitute life, because that's a problem when we look at sexual assault, because it affects people really for their life. And I want to read just into the record something I think is a very important statement that you put into this, into the amendment, which is line 13. In cases of sexual assault or abuse, is corroborated by medical evidence or a prior consistent statement. You want to say how important that is for survivors of sexual assault?
I think it articulates very clearly that physical pain and suffering by individuals that have been sexually assaulted or abused is allowed by corroboration of the medical evidence or prior consistent statement, and make sure that those people are recognized when it comes to the definitions of non-economic damages, both the physical pain and suffering, as well as mental and emotional pain and anguish.
Right, because the testimony we took was horrifying, and you know, the sexual assault case of the young gentleman that suffered just horrific depredations by family members and his younger brothers was so stunning that I think it galvanized everyone that on this bill, especially all the committee members, how important it is to make sure that that survivors of sexual assault and child abuse are given given the due they need to be able to recover the damages that they've incurred, and the difficult recovery that they have, and the long-term expenses that they have. So I just want to commend you for writing this amendment so strongly for them, because you know, having you know, words like life and you know, and as in cases of sexual assault or abuse, you know, having a prior consistent statement are so important to their cases, and more importantly to their health and well-being long term. That young gentleman that came onto the floor had thought about suicide many times, and my statement to him was that your life is worth saving. You are worth your value as a human being. And that we will always recognize that someone that's brave enough to come and testify, and the people that have been unable to do that yet need all the help that we can muster. And I want to thank you for these changes.
Thank you, Senator. I remember very vividly his testimony as well as your discussion with him thereafter. Move adoption of floor amendment number 1.
You have a few more people
questions
who would like to speak to you. Senator West, what purpose?
Just a question of the author.
Do you yield?
I yield.
Senator, in terms of, I'm on line 26, section 41107, I think it's a new section. I just want to make sure I understand what that is. I'm sorry, on the first page of your bill, on line 26, what is section 41.107?
Page 1 of the bill?
Of your amendment,
Of the
full
amendment. Thank you, sir. Let me look here. Yes, 41.107. This is the portion. 25, 26, 27 allows for the rules of evidence, judicial discretion to be consistent with all sections of the bill, other than the section that has matters admissible into evidence, which are statutorily prescribed to be admitted into evidence and do not allow for the rules of evidence for those areas.
What page of the bill is that on? The 41.107. I know my eyes are getting bad here.
Yeah, and if you'd like me to read out what those sections are, I'll be happy to, but
I'm just, in terms of the bill itself, what page is it on?
let me look here, sir. I got so many.
On 18? Okay.
The matters admissible into evidence are page 8, line 27. They include documents or information provided by the claimant under section 41.105A. And in the next section, number 2, referrals, essentially. That's what number 2 has to deal with. And number 3 are the treatment guidelines of workers' comp.
Okay, thank you.
Thank you, Senator.
Senator Eckhart, what purpose?
To ask questions of the author regarding the amendment.
Do you yield?
I yield. Thank you, Senator.
These are such difficult cases, and I apologize in advance for the very ticklish nature of these questions. With regard to the section that says, in cases of sexual assault or abuse, is corroborated by medical evidence or a prior consistent statement. These are difficult cases. When you say corroborated by medical evidence, do you mean medical evidence of sexual activity?
Well, there's obviously evaluations for sexual assault that can be done at the time of that tragic event, but this is it is corroborated by medical evidence or a prior consistent statement. So for those that have been sexually abused and it's been days, months, or years, a consistent statement would be anything from an affidavit to a police report to a persistent information of a close friend, neighbor, relative that they were sexually assaulted.
Are you aware that the vast majority of sexual assaults do not have along with them the requirement is penetration, and the physical evidence will not look any different whether it was non-consensual or consensual?
Then that would not be a part that would be obviously under corroborated by medical evidence, because there would not be medical evidence to that effect, as you were saying. But there would be prior consistent statement with the reporting of that to any individual eventually.
So and I agree with you there. There would not be corroborated medical evidence if it was non-consensual penetration but no other physical injury. With regard to prior consistent statements, there are often inconsistent statements over years as a victim comes to terms with the fact that they were sexually assaulted.
Again, Senator, the individual would need to make a consistent statement regarding their tort, their assault, their sexual abuse. It is for the jury to be deliberative in that case regarding the awarding of and the finding of a tort and the awarding of an award.
I do appreciate the effort in this amendment, but in experience with sexual assault cases, I am afraid that I'm afraid that this doesn't change much, but I totally applaud your intention with it. Thank you.
Thank you, Senator.
Questions on the adoption of floor amendment number 1. Is there objection? Hearing none, the amendment is adopted. Following amendment, Secretary, read the amendment.
Floor amendment number 2 by Schwertner.
Senator Schwertner, you're recognized.
Thank you, Mr. President. Members, this is the amendment that allows for the amount of healthcare costs to be adjudicated based upon the May 1st, 2025 Medicare fee schedule as adjusted by the CPI between May 1st, 2025 and the date on which the service was provided, or the date the service was provided to the individual, or the date the trial commences, depending upon which section of the bill is appropriate. Move adoption of floor amendment number 2.
Questions on the adoption of floor amendment number 2. Is there objection? Hearing none, amendment is adopted. Following amendment, Secretary, read the amendment.
Floor amendment number 3 by Johnson.
Senator Johnson, you're recognized.
Thank you, Mr. President. Members, Senator Schwertner, this bill addresses the collapse of various elements of damages from 6 down to 2. I want to talk just for a second about the difference between the common law and statute. Common law is not in statutes. It's law that has evolved in Western jurisprudence over centuries. The areas of law, the elements of damages that are being collapsed into 2 by this statute were developed over multiple centuries in every state in the nation and country of England, the United States, and they've been affirmed by the Texas Supreme Court, which has had a Republican majority since the 1980s. As I mentioned, 1980s, those of you who do math, that's 4 decades that the common law has remained in place. And I want you to note that the Texas Supreme Court has the power to rewrite all of this. They rewrite the law plenty of the time. They've never seen fit to change these elements of damages. The reason that they have not seen fit to change these damages, the reason that the law has evolved for centuries to have 6 different categories of damages, not 2, is that they're distinct. They are distinct experiences and they are distinct injuries. The courts accommodate this not by multiplying damages, but by delivering specific instructions through what's called a pattern jury charge. Today, under the law, a pattern jury charge will set forth each of these 6 areas of damages. I'll just mention what they are very quickly without reading all of them. Those areas are physical pain and suffering, mental and emotional pain or anguish, loss of consortium, disfigurement, physical impairment, loss of companionship. And you might notice in the statute that Senator Schwertner has drafted, and I know a lot of work went into this. I appreciate the effort, and I appreciate the sentiment that, hey, we can just consolidate these 6 different areas into 2. Look, we took the word disfigurement and stuck it in here. But it doesn't work quite that simply, and that's, again, why it evolved over centuries. We could have simply put that in. The Supreme Court could write it into their opinions today. But the way we accommodate that under the law today is you'll get a separate instruction, and in addition to that separate instruction for each charge, you'll have an instruction that you are not to double compensate. If you have awarded any damage, say, for disfigurement, or for severe emotional distress, or for loss of consortium, you are not to award any amount of money for that same element under any other category of damages. The law is already quite clear in this. The law is already well structured in this respect. The instructions to the jury are uniform in every court in Texas. This is the pattern jury charge that is proffered by the State Bar of Texas and compulsorily used by trial judges. It is not appropriate to merge loss of companionship with mental anguish. Senator Schwertner, I appreciate the amendment, is it forthcoming or it already has come, that will change a disruption in daily routine to a disruption in your life. And I know that you're responding to legitimate requests with that. But it responds to a substantial disruption in your daily life or your daily routine, and now it will be a substantial disruption in your life. If you are a victim of sexual assault and you're living with that trauma forever, will it substantially disrupt any particular moment of your daily life? Or is that a weight you bear every second that you're awake? It's not a disruption. It's a damage, it's a torment, it's a suffering, and it's a separate element that's been recognized in the common law for centuries, and it should not go away. We're not protecting any defendant by erasing the wisdom of a law that has evolved over centuries. If there's other problems that we're chasing here, we can chase them here. But I submit that this is not the method. That is why my amendment, which is far briefer than my remarks, simply strikes this section, page 3, lines 11 through 13. And after that, Senator Schwertner, I offer this, and members, to all of you, to not erase the wisdom that has been approved by our Supreme Court for 4 decades. Take that out of the bill.
Thank you, Senator. I appreciate you offering the amendment. I cannot accept this.
Excuse me. Senator Menendez, what purpose?
Questions of the author of the amendment,
Do you
please?
yield?
Yes, I do.
Thank you, Mr. President. Thank you, Senator Johnson. When I was reading your amendment, or trying to read your amendment, I was a little bit lost until you came to the part where you were talking about the jury instructions. And I think what I heard in your explanation is that the jury instructions currently that the State Bar of Texas and that most judges use don't conflate, don't try to merge all of these things into just past physical pain and suffering, into these nebulous things, and then say, but we define these on this other page. What you're saying is that they specify for the jury what they want them to consider, and therefore make it very clear for them. And so you're saying there's no problem here. Why are we trying to fix it? Is that what you're trying to say?
It's partly that there's no problem, Senator Menendez, and I appreciate the question, but it's partly that there's another problem that we're erasing with this bill. Take, for example, a spouse who loses their spouse. A wife is burying her husband. She is going to have severe emotional distress and grief at the loss of her husband, at the funeral, at the event, during the weeks and years of recovery.
Holidays.
But there's something else called loss of consortium and loss of companionship and loss of participation in the community, and that's quite distinct from the sadness. And when we conceive of the pain and the harm, we think of those distinctly. And what this bill would do is collapse them into one and deprive the jurors of the ability to really imagine what is the harm that's suffered here. That's why the law has separated them into distinct categories. And that's why the law has been very careful to say, don't double compensate the grieving spouse, but do consider the different ways in which we suffer.
Well, I appreciate your amendment. As a non-lawyer in the room, it is important for me to try to understand these as how would my constituents understand these? And if they were on that jury panel, how would I better understand? And it's much easier if you allow that full explanation of what I'm supposed to consider in awarding a jury. So thank you for your amendment. Thank you, Mr. President.
Question.
Senator Schwertner, on the amendment.
Thank you, Mr. President. Members, it is exactly because the jury instructions are different court to court, and the pattern jury charge is at times different court to court, that I cannot accept this. Part of this bill is making sure all those damages are recognized, but putting them in a more systematic fashion so that there's uniform application of the law when it comes to the awarding of non-economic damages, and the jury sees exactly what they are told regarding physical pain and suffering, and mental and emotional pain and anguish, and the definitions thereof, in their deliberation, and so they do not double count. They do not have ambiguity when they walk into that jury room that has been instilled in them by a plaintiff's attorney. So for that reason, Senator, I am not going to accept your amendment.
Secretary will call the roll.
Alvarado, Betancourt.
11 ayes, 20 nays. Amendment fails. The following amendment. Secretary, read the amendment.
Floor Amendment number 4 by West.
Senator West, on your amendment.
Thank you very much, Mr. President. Members, under the Texas Constitution, Article 3, Section 66, limitations of liability for non-economic damages. Economic damages refer to compensatory damages for financial loss. This excludes any related to physical pain, mental anguish, loss of companionship, disfigurement, or physical impairment. The legislature may limit liability for all damages other than economic damages. This particular bill puts in place a damage model that limits economic damages to 300% of the Medicare fee schedule. What this particular amendment does is strikes that language and basically leaves it to our healthcare providers, doctors like Senator Schwartner, Senator Campbell, and others, because we know that they are reasonable persons, and most doctors are reasonable persons. What we do is to put in the language, we strike, again, the Medicaid fee schedule and substitute in the usual and customary rate. And by doing that, we allow the facts finder, those jurors that we have on our jury, those citizens from our community, to make a determination as to whether or not those fees are reasonable. So that's what this does, and puts us in compliance with the Texas Constitution. Move adoption.
Senator Schwartner.
Thank you. Members, as was discussed, I believe this bill is completely in compliance with Article 3 of the Constitution. This amendment would replace the medically admissible billed charges at up to 300% and replace it with the usual and customary rate, which is essentially the rate set by that provider and could be essentially any amount. And for that reason, I am going to move not to accept floor amendment number 4.
I thought you would accept it.
Secretary will call the roll.
Alvarado, Betancourt,
11
Bigelow.
ayes, 20 nays. The amendment fails. Following amendment. Secretary will read the amendment.
Floor Amendment number 5 by Gutierrez.
Senator Gutierrez, on your amendment.
Thank you, Mr. President. Members, this bill is dangerous to your constituents. It limits the recovery that they'll be able to get at the courthouse for their damages. If they're severely impaired or paralyzed, it limits their damages at 300%. They need robotics. Not going to matter. It's not going to be allowed under this bill. But the bigger part about this bill, and that's pretty big, that's pretty horrible, and your constituents from Amarillo down to Brownsville to El Paso down to all the way to East Texas are going to have to face the reality that they're not going to have access to the courthouse because in many instances lawyers are just not going to do it. They're not going to go to the expense of having to fund these things if these damages are going to be limited in such a way that their clients are not going to be made whole in a real way. But worse yet, the bill creates this other section. You got to disclose your letters of protection to your doctors. You got to disclose any relationship you have with them. And all of it is intended to pervert this judicial system. All of it is intended to suggest that this information is relevant to the fact finder when we know that it is not relevant on causation or on the issues of negligence in any way. And so then the question is, well, Senator, it's relevant to the issue of damages. But all it does on the issue of damages, members, is it is intended specifically to tarnish that lawyer in the minds of a jury and that doctor in the minds of a jury, and limit how they will treat them in the area of damages. So what this amendment does is it eliminates that section altogether, goes back to the way it is, and tells us all that we will give everybody a rational bite at the apple, their opportunity to get justice at the courthouse without being tainted by the bias of this language. Because as I suggested earlier, it has nothing to do with the facts of the case, and it has nothing to do with the damages component. Doctors and lawyers in poor communities often have offices next door to each other. I was one of those street lawyers. Poor kid right out of law school, hung out a shingle. I didn't do this kind of law, but occasionally I did. And I'd send it to the one doctor that I knew that would sign a letter of protection, who wouldn't take any money, because these people didn't have any money. They didn't have any insurance. Most doctors don't want to go down this road because guess what? They need to get paid, and they need to pay their nurses, and they need to pay their staff. So the mere mention of these relationships, how many of your cases did you send to Dr. So-and-so, Dr. Smith, is highly prejudicial, and its probative value is highly outweighed by the prejudicial effect that it'll have on the jury. And so with that, members, I would ask you to consider one last thing. For those of you, and I know many of you have seen that documentary, Hot Coffee, understand that the constituents come in all races, colors, and creeds. They come from every part of this state. And sadly, sometimes they're injured by truck companies or oil and gas companies or the negligence of others. And remember that our actions today are going to affect the lives of our constituents. And this is an amendment that we can do to protect our constituents from a very, very highly prejudicial component of this proposed bill. Move adoption.
Senator Eckhart, what purpose?
To ask questions of the author of the amendment.
Do you yield?
Yes, sir.
Senator Gutierrez, your amendment does not change the fact that right now, under current law, these relationships can be discoverable. Your amendment simply says, go ahead and discover it. But you can't make this automatically admissible evidence if it has no relevance or its relevance is far outweighed by its prejudicial value. Correct?
Exactly correct.
Thank you.
The mere mention of the question in a courtroom creates the taint towards the plaintiff. And the proponents of this bill want that to happen.
Senator Hagan, what purpose?
To ask a question to the author?
Do you yield?
Yes, sir, sure.
Thank you, Senator sorry, Gutierrez. Pardon me.
Gutierrez, no worries.
Pardon me. Now, so this bill, as you understand, this bill covers a variety of types of cases, auto type injury cases, but it could be sexual abuse type cases, a variety of cases. And within even the auto, it could include commercial vehicles, but could and trucks, cars, personal vehicles, including any of those, correct?
Yes, sir.
Yet we keep continuing using examples of trucking companies, commercial trucking companies. Interesting. So let me ask you this. if a trucking company, continues a trucking company, seriously injures someone, and their negligence, their fault,
Yes, sir.
then that trucking company should be held accountable, responsible for that, and it's completely fair that they pay millions of dollars probably. I mean, you can't, if it's injures somebody for life or God forbid kills them, there's no amount of money that could make up for that, but they certainly should probably pay millions of dollars. You and I agree on that? That's fair, right?
It's absolutely fair, but that's not what this bill is doing. It's capping their damages.
Okay, let me keep going here. But if a system goes so far as to make awards way past the many millions, maybe even up to $100 million, where then it affects, let's say in the trucking industry, all trucking companies, even I told you about 90% of trucking companies are under 10 trucks, they're small trucking companies, small businesses. And as we talked about earlier, every Texan with their auto insurance and other costs, and their affordability issue we've talked about, if it affects all of them who had nothing to do with the case at all, is that fair?
Sure it is. And it depends on the facts. I didn't mean to be rude to you just now when I was looking
So it's fair if all the people who had...
I'm speaking now.
Okay.
I didn't mean to be rude to you. I wanted to look at the hot coffee award that so many people talk about. And so many people say, well, it's not fair that that lady in her 70s got a $2.7 million punitive damage verdict. But every case is different, and it's dependent on the facts of the case, and that's the answer to your question. The fact is that woman received third-degree burns. The fact is that McDonald's had been warned 4 times by the Department of the Health Inspector that their coffee was too hot. 4 times. They had other people complain that their coffee was too hot and that it burned them. But those burns on this lady's lap caused third-degree burns. And so every case is different. I had a young man that was cut in half by a bobcat, a skid steer. His boss, and more importantly, the man that was running this school district project for this new school, told him, the general contractor, told him, get up there and do that. Put him in a dangerous situation. Cut that boy in half. His manhood was gone. He was held together by ligaments. He lived for a day in the hospital, for a week, I'm sorry. He would tell his mother, he would write in the air, die. When there is negligence, sir, it is up to the fact finder to decide what those economic damages should be. Not some bill, not a bunch of legislators that say we're capping this at 300% of Medicare, because there is no price on a life. There's no price on those children that died on Uvalde, and there should be negligence there in that case, and they have nowhere to go. We make decisions every day, and business makes money every day. And just like I said, I owned a funeral home. I have to consider the expenses that go into that economic decision as you do with your trucking company. Are there exigencies? Are there excesses? Sure, at times, maybe. But I would argue, sir, that if you looked at most of those cases, rather than speaking in these generalities that Senator Shortner likes to talk about, in 8 years, there's been 104 cases over $10 million. My response to that is that's it. Have you seen the damages and the negligence that people have to go through? And I'll submit to you, Senator Hagenbu, that most people don't have access to the courthouse in a real way.
I'm sorry, the last thing you said was, well, people have...
I'd submit to you that most people don't have access to the courthouse in a real way. In the healthcare front, that's gone because doctors are protected.
You and I agreed in my first question that if someone's terribly injured like that, there's no amount of money and it should be millions. So we already agreed on that. Let me give you a real case then, because you talked about real life cases. Case I was involved with, helped with the mediation of this. Trucking company is going down a highway. Another car comes on, emerges on a ramp. Hits a trucking company, comes around, hits another car. The third car is serious. They're seriously hurt. The case ends up in mediation that trucking company who stayed in the lane, was going the right speed, logs were fine, all that. That trucking company's insurance company had a limit of $10 million. The lawyer asked to sue the trucking company for $26 million, but he knew that their insurance was 26. After 10 hours of mediation, they settled at $10 million, the limit of that trucking company's insurance. Then the plaintiff left. The mediator told us this. Plaintiff's gone. Plaintiff's interests are taken care of from a financial perspective. We stayed 3 more hours negotiating over what that lawyer could do with that case to advertise. So I spent the rest of the time talking about if that lawyer could advertise this case to get additional cases, make more money, whatever he wanted to do with it. Does a system like that seem fair to you? It promotes that kind of...
That the lawyer, through what he earned in the case, that he would be allowed to advertise?
Yes, beyond argued for the plaintiff and take care of the plaintiff, he's arguing for his own interest to be able to advertise for those huge settlements like that.
You get to advertise your trucking company, sir. I mean, that's capitalism. Tony Busby sat here for 3 weeks and he advertises that he was sitting here for 3 weeks and that he won all day long. I see it in his ads all the time. I mean, these things happen. I mean, I don't know if that answers your question, and I apologize if it doesn't. But if I'm a successful lawyer, then I should be allowed to advertise. If I won a $10 million judgment, why can't I advertise that?
Okay, well, that's the point.
We don't live in communist China.
That's the point here. So you don't like the fact that a jury who's trying to decide on the financial settlement here, they're looking at plaintiff and a defendant. They both have a financial interest. But there's a third party who has a big financial interest in these cases. It's the lawyer standing in front of them, right in front of them, arguing with them to maximize the amount of money paid. But those folks, those folks in that jury box shouldn't be aware that person has also as a third party who has a financial interest.
It is completely irrelevant for the fact finder to understand that we're talking about negligence. That's one thing. The facts on causation and so on, and whether a tortfeasor is negligence, a trucking company, to your point in your example. And then there's damages. He's already capped damages. You and I just agreed that someone should be able to get millions of dollars if they die or if they're in a hospital and so on. Unfortunately, he doesn't agree. His bill caps damages at 300%. But to your point, and to my amendment specifically says that the disclosure of these relationships with the lawyer and the doctor down the street is absolutely irrelevant to the fact finder. And what it really does is it prejudices the fact finder, the jury, against that lawyer and against that doctor. And I would argue, Senator Hagenbu, as I did earlier, that that's absolutely what the proponents of this bill want. They want a judicial system that prejudices, that taints a jury pool against plaintiffs. Because everybody wants to talk about hot coffee, but they never want to tell the truth. And the truth is that little old lady had third-degree burns.
Do you believe me that I told you the truth about the case I was just talking about, and that I believe that they're fairly common?
The truth that a lawyer won a case, I think the case that you told us, and I'm not being facetious here, you said that he won and then he was allowed to advertise that he won.
When the trucking company had really no fault.
Well,
but it doesn't matter.
I wasn't there, sir, and I don't know the facts of the case, so I don't want to.
$10 million settlement, but that wasn't quite, it still was a threat of going beyond and piercing that for the trucking company to pay more. I'd
be glad to sit down and look at the discovery of the case with you anytime. And so then I'll give you a full opinion, because I'm not going to sit here and say, be part of a discussion or a debate where it says, this happened here. And so I guess we often say on this floor, I'll take your word for it. But just about every injury case I've ever seen in my career of 26 years, I've seen fault and I've seen damages, or I've seen no fault, and you don't win. That's the way our judiciary works. So for some mediator to settle a case for policy limits. And you're telling me, I'll take your word for it, I suppose. But I'd have to say there was some fault there, and I'd have to say there were some damages. But you and I'll be glad to visit with you, and you can show me the whole file. I'm glad to look at it.
All right. Appreciate it. Thank you for,
Yes, sir.
Thank you, Mr. President.
Senator Schwartner on the amendment.
Thank you, Mr. President, because it is relevant and necessary to disclose information to the finders of fact regarding the affiliations between a plaintiff attorney and a medical doctor that is affiliated with that plaintiff attorney, are bills and itemized statements and written agreements between various individuals. I think it is absolutely vital that this bill portion be kept, and therefore I oppose the adoption of floor amendment number 5.
Secretary will call the roll when ready.
Alvarado, Betancourt, Birdwell.
11 ayes, 20 nays. The amendment fails. Following amendment. Secretary, read the amendment.
Floor amendment number 6 by Eckhart.
Senator Eckhart, you're recognized.
Thank you so much, Mr. President. This is a very simple amendment. I'll give you an example of why this amendment is important. Last month, a truck driver caused a multi-car collision on I-35, killing 5 people and injuring roughly a dozen people. Of the 5 people that were killed in the collision, one of them was a 78-year-old and 2 of them were small children. So what this amendment seeks to do is simply strike the statutory admission of the workers' comp guidelines as evidence of necessary care, since, based on our back and forth between Senator Schwartner and I, we established that in some instances, this evidence is of no probative value, or at least more prejudicial than it is probative. So by striking the portion of the bill that requires the admission of workers' compensation guidelines as evidence of necessary care, it restores the circumstance to what is already the case. Already, under current practice, under current procedure, under current evidentiary law, either party can try to admit the workers' comp guidelines as evidence of necessary care, but it must be relevant and have more probative value than prejudicial value. So my amendment simply strikes those few lines of the bill that make the workers' compensation guidelines admissible automatically. And I hope that the author of the bill will accept the amendment.
Senator Schwartner.
Thank you, Mr. President. I don't think it does any harm to allow for those treatment guidelines to always be entered as a component of a mandatory admissible into evidence fashion. If they're not relevant, they're not relevant, but I think in the vast majority of cases, they are reasonable to include them and necessary, and therefore I do not accept and oppose floor amendment number 6.
Secretary will call the roll when ready.
Alvarado, Betancourt, Birdwell.
11 ayes, 20 nays. The amendment fails. Members, that was the last amendment. You recognize passage to engrossment.
Thank you, Mr. President. I move passage to engrossment of committee substitute Senate Bill 30.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanc.
20 ayes, 11 nays. I think you'll have to hold right there, unless you can find 5 friends. We're coming back on a new day.